Aloha. Welcome to Ably Seminars sessions. This session, we're going to continue the elements of a deed. As you can see, there's lots of things that are in the deed that the attorneys have to take into consideration when they're drafting the deed. One of the parts of the deed is that you have to have a legal description. I mentioned this in a previous tape, that it's not the tax map key number or an address. This is a legal description put together by the engineer or the surveyor, and the attorney will then draft it into written form. So who's really concerned about a legal description? One is the attorney. Second is a title insurance company. Third is a title department of an escrow company. And then, of course, the lenders and anyone else that's involved. But legal description must be put into the document. And if we read a legal description, it's going to be gibberish, and we can't even find that place unless we have an address or a tax map key. So legal descriptions are necessary for legal description, but not really for practical finding of the lot. So that's one. The other clause is what they call habendum clause. And again, I'm not an attorney, and I don't know what the heck this means, but from what I've read, it says the right to have and to hold the property. So that means that with the habendum clause, the grantor is giving the grantee the right to have and to hold. Now, the grantor may say, but there's some restrictions, and I'll give you everything but certain things. So they may have some restrictions as to if they have full use of the property or if there's some reservations in favor of the grantor. Usually we don't see that, but they could. Then there's what they call warranties and covenants. And I mentioned this before, that are there any guarantees that the seller is giving? And typically it will say, I give you the title to the property free and clear of all encumbrances, except there's a clause in about 90% of the deeds where it says the mineral rights are reserved to the state of Hawaii. So if you own the land and there's minerals, gold, oil, diamonds on your property, those minerals belong to the state of Hawaii and not to you. How did that happen? Legislative action. So I've read that about 90% of the properties have the mineral and metallic rights reserved to the state of Hawaii. And why 10% didn't have that reservation, I don't know. But that's just the way it is. You also need to have what they call the grantor signature. The grantor has to sign saying, hey, I'm transferring this title. And that signature usually is acknowledged by the signer and notarized by the notary. Because if you don't have a notary acknowledging that they saw the identification of the grantor and had driver's license or passport or whatever, then you cannot record those documents at the Bureau of Conveyance. So you must have a notarized sheet that says that the grantor signed the document and gave proper identification. Another component of the deed is what they call delivery and acceptance. And this is really important because I'm the grantor, I signed it, I had it notarized. You're the grantee, and you're going to get it from me. Either you bought it or I'm giving it to you as a gift, either as part of the probate courts, or I'm going to give it to you before I die. So it's called delivery and acceptance. So I'm the signer, and I notarize it. Now you have to accept it. So I got to deliver it to you, and you have to accept it. What happens when I signed the deed, I had it notarized, and I had the document on my desk at home, and I die overnight of a heart attack? Has it been delivered and accepted? No, because it's still at my house. But what if I signed the document and I gave it to escrow, or I gave it to an attorney? Has it been delivered and accepted? If a third party receives the document then it's deemed to have been delivered and accepted. Even though the grantee didn't get it yet, it went out of my hands and it went to the hands of the escrow or to an attorney, a third party, then it's deemed to be delivered and accepted, which is very interesting. So delivery and acceptance must occur for the transfer to be made. There's a part of the deed that says, should it be acknowledged? And what that means is that on the signer, I give the notary my driver's license. It has to have a picture ID or a passport. And by the driver's license or the passport has to be current and valid. It cannot have expired. So I give the identification to the notary. So I'm acknowledging that, hey, I'm signing this of my own free will and choice, and no one's forcing me to do it. The notary will then notarize the document with all their stamps that they have, because they're basically an officer of the court system. So now it's been acknowledged and notarized. And the last part of transferring title is what they call recording the document. Do you have to have it acknowledged and notarized? And do you have to have it recorded? And the answer is no. But should you have it acknowledged and notarized and recorded? And the answer is absolutely yes. Here's why. If the document does not get recorded at the Bureau of Conveyance, then nobody knows that document exists. It's a secret, because only the person that has the document knows that it's been transferred. But in order to let the whole world know that the transfer has been made, you need to record it at the Bureau of Conveyance, and it gives what they call constructive notice to the rest of the world that a document exists. And even if you've never saw the document physically, you know it exists, and you can actually pull it up on a computer now. With the advent of the computers, you can actually find documents. And that's constructive notice to the rest of the world that a document of this type exists. So should you have it recorded? Absolutely. And if you borrow money from a bank, the bank wants a mortgage recorded at the Bureau because they have what they call secured creditor's position. Because if the bank does not have it recorded, then they're just a creditor without a secured position. But if they record it first among all of the banks or the debt, then the first mortgage to record gets first position. Second mortgage, record second, they're in second position, and third, and so forth. So recording the documents is critically important to preserve the rights of being secured, and also to give notice to the rest of the world that this document exists, and that's called constructive notice. So hope you learned something about the components of a deed. We covered 13 elements of a deed. Hope you learned something and it's beneficial to you. Aloha.